Distinction between tort and breach of contract. First, on the basis of fixation of duty. In tort, the duty is fixed by the law itself, whereas in contract, the duty is fixed by the party themselves. Second, on the basis of attribution of duty. In tort, the duty is towards every person of the community or society, whereas in contract, the duty is towards specific person or persons. Third, on the basis of violation of rights. A tort is a violation of a right in rem, that is, a right vested in some determinate person and available against the world at large, whereas a breach of contract is an infringement of a right in personam, that is, of a right available only against some determinate person or party. Fourth, on the basis of need of privity. In an action for tort, no privity is needed or is required to be proved, whereas in a breach of contract, privity between the parties must be proved. Fifth, on the basis of motive. In tort, motive is often taken into account, whereas in breach of contract motive is not relevant. Sixth, on the basis of damages. In tort, measure of damages is different in different circumstances, which may be nominal or exemplary, whereas in breach of contract, damages are awarded in the form of compensation for pecuniary loss suffered. Seventh, on the basis of suit by third party. A third party can sue for tort even though there was no contract between the person causing injury and the person injured, whereas a third party to a contract cannot sue for breach of contract except in some exceptional cases. Eighth, on the basis of intention. Intention is sometimes taken into consideration, whereas intention, in case of breach of contract, is of no relevance. Ninth, on the basis of concern. Law of tort is concerned with losses, whereas contract law is concerned with promises. 10th, on the basis of period of limitations. Limitation begins to run from the date when damages occurs, whereas limitation commences when the breach of obligation takes place. Distinction between tort and breach of trust. First, on the basis of damages. Damages in a tort are unliquidated, whereas damages in breach of trust are liquidated. Second, on the basis of origin. Law of torts has its origin as part of common law, whereas breach of trust could be redressed in the court of chancery. Third, on the basis of law of property. Law of tort is not regarded as a division of the law of property, whereas law of trust can be and is regarded as a division of the law of property. Distinction between tort and quasi-contract. When a person gains some advantage or benefit to which some other person was entitled to, or by such advantage another person suffers an undue loss, the law may compel the former to compensate the latter in respect of advantage so gained, even though there is no such contract. The law of quasi-contracts covers such obligations. First, on the basis of damages. A claim for damages under law of tort is always for an unliquidated sum of money, whereas a claim for damages is for liquidated sum of money. Second, on the basis of attribution of duty. Under law of torts, the duty is towards persons generally, whereas in a quasi-contract, the duty is always towards a particular person. The common point between tort and quasi-contract is that the duty in each case is imposed by the law. However, in certain cases, where a tort has been committed, the injured party has a choice of not bringing an action for damages in tort, but of suing the wrongdoer in quasi-contract to recover the value of the benefit obtained by the wrongdoer. When the injured party elects to sue in quasi-contract instead of tort, he is said to have waived the tort.